All right, we're still here at the firm at Ozment and Copeland, here for round two, and we've got another interview.
Larry, Larry Copeland, right?
That's correct.
Yeah. Tell me a little bit about yourself. How long you've been in practice?
Been in practice for 14, going on 15 years, and solely a criminal defense aspect.
Criminal defense aspect. Do you do? Is most of your work private or court appointed?
I would say the majority of my work is court appointed, actually, at this point, and has been for some time. I do have, I would say, it's running probably about 60 court appointed, 40% private.
You're out there fighting for the constitutional rights of these defendants every day, aren't you?
Oh yes, sir.
You have a lot of fun doing that, don't you?
I do. I live for that. That's the reason I went to law school.
I can tell by talking to you a little earlier that you're quite passionate about that.
I'm very passionate about that. I think it's a great privilege to be able to stand up for someone and effectuate their constitutional rights, especially if they're in a position not to be able to afford that.
Well, the situation we're dealing with now in this potential rule amendment, you know, enjoying fighting for the constitutional rights of folks, it's an honor. It's an honorable thing to do. And you're aware we're engaged in a fight opposing this amendment to Supreme Court Rule 13. Do you see that opposition as being a fight for the protection of the constitutional rights of the defendants in the state?
I most certainly do. I don't see why you'd want to have a contract defense. They do that in Arkansas, if I'm not mistaken. I'm also licensed to practice over there. And what you see over there is that those attorneys end up with workloads very close to just being a public defender. And they're not able to pick and choose what cases they want. They're not able to effectuate the rights of their clients to a degree that it should be done, because they're overloaded with the amount of work that they get underneath the contract that they present. Now, there's language here talking about appointing people based on cost. That in and of itself is abhorrent. I thought what we were here to do was to effectuate the Constitution and protect our clients, not to come out here and see who's the cheapest boy in the ring.
Well, and let's talk about that issue for just a second, Larry, because you know everybody's concerned about cost. I mean, we all know that the Indigent Defense Fund has come under attack every year, every legislative session for the last multiple years. But you know, in the end, does reducing the amount that you're paid, what's that going to do to you? I mean, do you make enough as it is?
No, it's impossible to. I feel bad now to having to juggle my clients and what work I do on what cases, because I do have a lot of appointed work, and I know that some work's going to pay more than others just because of the nature of the case. So you're already in a position of having to juggle what you do for your clients based on the overhead of your firm. And if you go down to a contract and you're getting, let's say, 20 cases a month or whatever it is per your contract, I don't see how in the world you can ever effectively represent your clients underneath that basis. It's just not correct.
Now, you work hand in hand with multiple assistant district attorneys, I'm assuming.
I do.
In the last 12 years, are you aware of how many raises they've had?
I think 3. But I'm not positive.
And how many as a not public defender, but as an indigent defense attorney, how many raises have you had?
None.
Now, another question, because you do so much of it, it's probably best posed to you. We hear the sound bites and we hear the type bites, and about $40 and $50 an hour in your non-capital cases. Is that a true figure of it being $40 and $50 an hour?
It is. That's exactly what we do.
But is it a true calculation of what you actually are paid for the hours you work?
No, not at all.
And why is that?
I'm capped. I only make so much money off each case as it is.
So if you were, and I don't know if you've done this, if you were to take into consideration every hour you worked for indigent defendants in the state of Tennessee and calculated that and divided it into the amount of money you were actually paid by the state of Tennessee, would that be right about 40 and 50, or would it be substantially less?
If I billed for every hour I spend on a case, which I do not, I would tell you that probably my hourly rate, shamefully enough, would probably drop down to be anywhere between $15 and $20 an hour.
And you know, that you're in the game because you love it.
Right.
And are you saying that you're really at about the bottom level of what you could do to stay in this game?
I'm scraping.
You're scraping. And how does this contract position, as you read the rule, does the contract attorney seem to promote paying attorneys more or less?
Well, I think it effectuates a less rate, a less of a rate. I mean, if you're going to do contract, there's no assertion there as to what that workload should be, and that's scary. As we've talked before in our previous discussion, we talked about the judges appointing the right attorney for the right case. And if you're talking about attorneys that are coming into contract, then you're talking about people that are looking at them solely on a monetary basis. They're not looking at it, they're not appointed because they're more adept at trial work, or because they fight for their clients to the end of the road, or they're just solely appointed based on how much money they're going to be getting paid, or how much money they're willing to accept for that contract work.
So I guess you would say, with your, 13 years of experience in the criminal defense world, that the judge presiding over the case is the best person suited to determine the attorney that should be appointed, and a much better position to make that determination than a bureaucrat in Nashville.
The judges here know who fight for their clients. They see us on a daily basis. They watch our trial work, they watch our motions, they watch what we do for our clients and how we conduct ourselves.
In all fairness, the opposition has received multiple reports that this really isn't that big of a deal, because the AOC only wants to apply this to the mental health docket. Do you feel comfortable with this rule being adopted as it's written, if that is the intent of the administrative office of the courts and the Supreme Court?
I think that's a bunch of poppycock. Mental health docket really runs through the public defender's office as it is.
So you don't feel comfortable with the rule as written?
No, sir, not at all.
Even if you were for contracting attorneys, would you feel comfortable with the rule as written?
No, I would not be.
Is this rule in the interest of the taxpayers of the state of Tennessee?
It is in the interest of the bureaucrats of the state of Tennessee to watch the purse strings of this nation. It is not in the interest of the indigent defense, and I'll be damned. That's what the Constitution was written for.
That's right. And wouldn't you agree that every judge, including the members of the Supreme Court, took an oath to defend both the constitutions of the United States of America and the state of Tennessee?
That is correct.
If this rule is passed, do you think they're in keeping with their oath or not?
No, as I indicated, they're changing their oath to watch the purse strings.
Anything else you'd like to say regarding this amendment?
I think it's a bunch of poppycock. Leave it as it is and give us some more money so we can represent our clients to the fullest of our ability.
Thank you very much for your time, Mr. Copeland. You do a great service to the state of Tennessee, and everybody should stand and applaud you, and everybody else who does work like you, because you are the defenders of the constitutional rights of us all.
Thank you.
Thank you very much.